Item number 18, Your Lordship. 18. 18, Your Lordship. Conducting counsel without of station, Your Lordship. Matter may be listed after 2 weeks.
You are Mr.
T. Tarin.
On behalf of TP Tara
Jumgam Jine, JG.
Chumang,
Yes.
who is out of station for adjournment. This is along, this is the matter of 2 weeks.
Obliged.
My lord.
Yes.
My lord, I beg to mention item number 3.
3.
3. On behalf of Mr. K. Lawyer for the petitioner. My lord, this matter may be placed after 2 weeks.
The other side?
Council is out of station, my lord.
No, the other side.
Others consent has taken, my lord.
You have taken consent.
Yes, my lord.
Are you sure?
Yes, ma'am.
With the consent of the other side. You are Mr.
T. Mite, my lord.
T.
Mite. My lord, interim may be continued meanwhile.
On behalf of N. Ratan,
No, my lord, K. Lawyer.
K. Lawyer.
Yes, ma'am.
With the consent of the other side, matter is adjourned for today. List the matter 2 weeks.
Yes, my lord. Much obliged.
My lord, I'd like to mention item number 13 on behalf of Mr. D. Gogoi.
13,
13, 1-3.
1-3.
He is a Guwahati-based lawyer. He has asked me to make a prayer for listing of the matter after 3 weeks.
You are Mr.
R.L. Fungali. There's an interim order that may be continued.
Interim is there. Okay, it's interim is extended. After 3 weeks.
Much obliged.
May I, Lordship? I would like to mention item number 4. Kindly this, yes,
Yes.
kindly this matter may be fixed on 19 September. Since the main counsel appearing in this matter is from Guwahati due to of some personal reason he couldn't come, and I have taken consent from the other party.
Okay, you are Miss.
T. Choten.
Praise for adjournment is the. Who is from Guwahati?
Shri Abhijit Bhattacharya. Also, Your Lordship, I would like to mention item number 16.
Wait.
This matter may be also fixed on 19 of September.
19.
Next, sir, 16.
16.
Yes, my lord.
Well, item number 4, this matter may be fixed on 18 as a fixed matter.
Fixed.
Fixed. This matter is pending since very long. It's that is for the cancellation of bail, man.
Cancellation of
Bail,
bail.
man, filed by the state, man,
Filed by the district administration.
by the state government.
State government.
State.
The matter will be fixed on 18.
18,
19.
19.
19.
Yes, 19 of September.
19. And other one?
Item number 16.
16.
Yes. This matter may be also fixed on 19 of September.
19.
Yes. In the both matter, the main counsel is same.
16 is for fixed for hearing. 16 is for hearing.
And they have changed the advocate, so Vakalatnama has
Who is
yet to be
an
filed.
advocate?
Same, sir, Shri Abhijit Bhattacharya.
His name is not reflected in the cause list.
Yeah, because Vakalatnama has yet to be filed.
Okay, 19. Same 16.
Obliged, my lord.
My lord. I beg to mention item number 17, ma'am.
17.
Yes, ma'am. I have taken consent from the other side, madam. Matter may be taken after 3 weeks.
Why?
Madam, there is some difficulties, ma'am.
Whose difficulty? 18 matter after 5 years.
Yes, madam.
You're for the petitioner.
Yes, madam. I am for the petitioner.
You're for the petitioner.
Yes, madam.
On the other side,
I have taken consent, madam.
Your lordship, I'm for the respondent.
you're for the respondent.
Yes, your lordship.
You have any objection?
No objection, your lordship.
No
No
objection.
objection. Matter may be fixed after 3 weeks, your lordship.
So and so. Press for adjournment, the consent of the same.
Obliged, your lordship.
All right.
May I lordship,
Yes.
I beg to mention item number 5. The connecting council is out of station. The matter may be listed after 3 weeks.
Yeah, Mr.
Bibo,
May I, my lord? My lord,
3 weeks.
my lord, my interim order is there, my lord, in item number,
Which one?
item number 5, my lord. I am for the petitioner, my lord.
Interim order, huh? 5. Please.
My lord.
My lord, this is unlisted matter. This is Arden Bell matter. Ray Tagam versus State of AP. It was,
What do you want? Listing?
yes,
Tomorrow? Tomorrow?
today it's very urgent because,
Bail matter. Bail
yes,
matter.
Bell matter is there. Because there is a case, incidental case that apart from IO and OC, there is a physical assault to a lady who is mother by one police officer, and even subsequent that has been inquiry has been set up by the learned judicial magistrate first class. Repeatedly it's going on, and after that, after observing that incident, judicial magistrate first class has taken judicial custody for the alleged accused. But apart from that, repeatedly they are taking the remand in different cases. So
On today.
yes.
Okay, at 2.
Obliged.
Lordship, I beg to mention item number 8.
8. Yes.
Yes. So matter may be fixed for 19.
19.
Yes, Lordship.
Lordship, I am for the respondent.
You're for the respondent.
Yes.
Why this one 19?
Uh,
Some other matter also fixed on 19.
19, because some important matter is being concise here today or between these days. So on that 19th, I took the consent of the other party also.
19, yes. Oh, okay.
Much
Alright.
obliged.
Lordship, I would like to withdraw the list number 6, cost list number today, cost list number 6. So,
Want to withdraw?
yes,
Your lordship,
liberty to file the fresh.
I have an objection, your lordship. There is a issue here in this case. Let the matter come up, your lordship.
My lord, let me submit.
Then wait for some time.
Let the matter reach your lordship.
Okay.
My lord, you, as per according to there is a lot of the citations there.
Wait for some time. Let your turn become. Wait for your turn. Any other? Yes.
My lord, I on behalf of G Kato would
Which
like
man?
item number 15. Would like to,
1-5.
yes. My lord, the leading counsel is out of station, so matter may adjourn and list after 3 weeks.
G.
G Kato.
The other side.
I have taken consent from other side.
Ricardo, what's the problem with them?
My lord, he's out of station for
2000,
some
he is
domestic
out of
work.
station.
Yes, for domestic.
Was 2016 matter, you are not ready to argue the case.
Lord, make them.
You are Mr.
N. Karga.
On behalf of Mr. Vijay, please for adjournment. With the consent of the other side. It appears that it's a hearing matter. The case is for pending in the court for since 2016. So adjournment is granted with the condition that on the next week's date, both parties argue the matter. Yes, fix the date for 1 week. Give me the date, please. After 1 week. Yes. 20. And
Applies.
for adjournment, we allow to either of the parties.
May please your lordship. Lordship, this regular bail application under section 439 CRPC.
439, yes.
Yes, your lordship. In connection with Alo PS case number 31 of 2023. Under section 409/34 IPC, your lordship.
409/34. CD is received.
Your lordship, on last occasion, CD was not called for, your lordship.
Then
They-
CD will be required.
Yes, your lordship.
Yes.
CD was not called for, as per the record, your lordship.
Arts one, so. Well, it is also present. Call for the case direct. Date, please. Date.
Date, your lordship. Your lordship, let it be on 20.
Yes,
20.
20.
Yes, your lordship.
20.
Deeply
Just
obliged.
prior to that, let's write it. It's an application, work for 39 CRPC in connection with Alo PS case number 3123 under section 409/34 IPC. Then call for the case direct.
1 and 2, same, arising out of same, your lordship, FIR, in both the case, 1 and 2.
1 and 2.
Yes, yes, common order,
1 and 2 also.
deeply obliged.
Lordship, matter may passport for some time.
For some time,
Yes.
19.
Yes, 19. Yes, leading counsel is in under. Possible. Hello.
Yes, for 20. 20. Yes, please.
I'm for state.
You for the state.
Yes.
Anybody for the petitioner?
No one appearing.
It is. However, one and additional PPS present, they have the state. It's the matter of the 1 week.
Obliged.
May I please your lordship?
Please.
This is a petition under 482 CRPC lordship for quashing of FIR. The FIR is at page 11 lordship. The typed copy is at page 15.
Page?
15, 15. Lordship may see this FIR has been lodged on 4th March 2023. But while we in the contents of the FIR, while we go in para 5, next page 16, that at present the alleged accused is arrested by Itanagar police and has registered the case while Itanagar PS case number 7323 under section such and such, and Itanagar PS case 281 of 2022 under section such and such. Lordship, this Itanagar PS case number 7323 was lodged much after this 4th March FIR. So how come the complainant has come to know about that Itanagar PS 7323 will be registered after around 20 days when he was lodging the case on 4th March 2023?
Your PS case number,
Pangin note.
Pangin.
Yes, lordship.
Pangin PS case number 423. The same. Same sections, the same section, construction, industrial construction. Yes, please.
My lord, since this matter is for the quashing of the FIR.
So call for the LCR.
Yes, ma'am. Not my lord, the case diary, scan copy
Case
of the
diary.
case diary.
Charge sheet is not yet been
No,
submitted.
no.
482 CRPC. Hard transfer transfer. For quashing the FIR. In connection with Pangjin base case number 0423 under section 120B /420/468 471 467 by 34 IPC. Or for the case diary.
My lord, the scan copy of the case diary.
Scan copy, no?
Yes,
Scan copy of case diary. Issue notice to respondent to.
private respondent, ma'am.
Issue notice to respondent to. The petitioner shall take steps and service of notice to the respondent to with the registered date as well as issue process returnable within 4 weeks.
In the meantime, further proceeding may be state, lordship.
Or for the, to release the matter accordingly after 4 weeks.
Much of
Deep view.
My lord. My lord, this is application under 482 CRPC.
480.
Yes, for quashing of FIR and charge sheet rising out of the Doimuk PS case number 06/2015. Registered under section 341, 427, 307, and 326 of IPC. My lord.
Depending in the court of sessions.
Yes,
Sessions court.
yes, my lord. Now the trial is underway.
Trial is under.
Yes. And the parties have settled the matter.
Parties have settled the matter.
Yes, this is joint application. Joint application.
Joint application.
Yes.
This is not compoundable offense,
Yeah.
307 and all this thing.
Yes, that is there, my lord.
That is not possible.
Yes.
Okay, yes.
Yes, ma'am.
LCR.
Yes. Scan copy and first.
Well, I have interim prayer.
Yes.
Interim prayer. Interim may be granted, my lord.
Interim is.
Yes. No interim, but till returnable death, interim may be granted.
482 CRPC. Washing. The first like charge sheet. In connection with sessions case number 3760.
Yes, 3716.
Pending in the court of sessions court, pending in the court of Which court?
UPA, District and Sessions Court,
District
UPA.
Session Judge?
Yeah.
There. Pending in the Court of Sessions Judge UPA. Under section 341, 427, 307, plus 326 IPC. Call for the scan
A
copy.
scan copy of it, yeah.
Scan copy of the LCR as well as the case diary also, no?
Yes.
It's also required.
My lord,
Yes,
deposition of PW 1, 2, 3 has already been done. Now
Already?
PW, yes,
Been recorded,
yes.
then.
So
that's
now
case,
the next date is fixed for
further hearing.
yes, further hearing of PW 4 and 5 and 6 on 5th of October. So till that the proceeding may be stayed.
You have submitted the copy of the evidence. Evidence of the witnesses.
No, my lord.
Then we have to see whether there is any material, yes or no.
The copies of our last proceeding has been annexed,
Which one?
summon copy,
Page number?
page number 47 to 49. Page number 47.
Including the evidence of the witnesses recorded so far. So date please within 2-3 days.
Yes.
Yeah. The scan copy, no, it is
Scan.
possible through the registry.
So
Registry will.
registry will provide.
So registry is directed to do the needful. Next date is fixed on
5th October.
5th October.
Yes.
So within this month,
Yes, ma'am, it can be done. After 1 week.
after 7 days, no?
Yes, ma'am.
This date is 20? 20.
20, my lord, I may not be available, my lord. Yes.
20.
Yes, after 20, any date.
20?
After 20, any date.
After 20. Then
Yes.
21 it is open.
23. I don't know,
23.
22. So till that, my lord, interim may be granted and further proceedings may be stayed.
Deeply of this.
Number 23.
Lord, in this case, yesterday it was listed. Other side have raised the issue of maintainability. So today this was for hearing on,
Okay, yesterday, no?
yes, sir, this, the other side. They have taken time
He
for
wants to argue the matter, no? She
Yes.
Has raised some points,
Ah.
law points. on
law
the issue.
points. They say it's not maintainable.
So what is coming?
That side seems absent.
Then you will come at 2.
Fine. Hello.
Yes,
Uh,
please.
Yes. My lord, liberty to withdraw. I would like to pray before this court that I may be allowed to withdraw and liberty to file fresh.
Want to withdraw?
Yes,
Your lordship may kindly see the last order first, your lordship, before considering his prayer. Your lordship. He's already in interim bail, your lordship. Interim protection. There is an observation from this honorable court, your lordship. Order dated 16/8/2023, the coordinate bench. In page number 3, your lordship, the case diary produced support the allegation made in the FIR lodged by the project director DRDA, Upper Subansiri District, Daporijo. The case diary also disclosed the petitioner is undertaking a construction of RCC structure after dismantling the government quarter. On being apprised about the incriminating material against the petitioner in the case diary, the learned counsel of the petitioner, Mr. T. Dukam, has fairly submitted that the petitioner may be given some time to dismantle the RCC structure constructed by the petitioner at all ZPC office after the DRDA go down, number 1, and SP type 2 quarter was dismantled by the petitioner. So the said premises is hand over back to the appropriate authority. As prayed by the learned counsel for the petitioner, Mr. So and so, 3 weeks time is given to the petitioner to remove the RCC structure constructed by him on premises of DRDA go down number so and so at all ZPC office at Daporijo, Upper Subansiri District. List the matter after 3 weeks, on which up to date case diary shall again be produced by learned additional PP. Your lordship, as per the latest updated case diary, your lordship, he has not complied with the direction, your lordship. He has not dismantled it, and maybe for that reason they are trying to withdraw this application, your lordship.
Not that, my lord.
Yes, yes, yes.
My lord, not like that. Exactly, they have not complied as per section 41. They have not given any notification. This is latest.
That is different issue.
Yes.
They violated the order of the court.
No, my lord, actually, still I'm in the under treatment.
Your lordship,
So it is not possible for me to comply that. I'm still under medical. This court knows.
your lordship, see the page number 2, your lordship, in the case diary.
My lord,
In the column 2, your lordship. Page number 2, your lordship, it's written
Page 2.
page 2, column 2, your lordship. Now self-return to PS, your lordship.
my lord,
Wait.
Now self-return to PS from the place of occurrence after complying of the court order by case number so and so. The alleged accused Sri so and so Maing has not complied the order of the honorable court, nor any steps have been taken to dismantle the alleged illegal construction of RCC structure at government land, which has been allotted to Dapo Anna Self-Help Group. It seems he is adamant disobeying the order of the honorable court, which he has been given ample 3 weeks time for dismantle of the structure, your lordship.
Okay.
yeah, my lord,
Given an-
yeah, my lord,
This time.
still I am in a under medical treatment.
Where is
So I have not done anything, and this is allegation. The court, if my submission is that,
You were asked to remove also.
yes, that's why.
Then?
But this is, my lord, this is bail matter. So just like a conviction,
That is different.
and
Then
my
you
my
have
lord,
to- then you
liber,
have-
this is my liberty. I am the petitioner in the case, so I may be allowed to withdraw. So so that I may be, I'll file afresh, and yet new judgment is there. A lot of the Supreme Court judgment is this. If this court is allowed, this is Anas Kumar versus State of Bihar. Here, this below 7 years.
That is different.
It is not that, it's not mandatory to arrest. So I'm comply with the, I'm already complied with the order of the honorable court, last previous order. I've already gone to police station also.
On the basis of the issue, you were granted the pre-arrest bill. Pre-arrest bill was granted to you, no, on the basis of this. But there are some conditions that you have to remove all such structures. You didn't do it. Then
No, my lord, still I'm in the medical treatment. So serious ailment I'm.
where is
So
your
if
medical
then,
certi-
if this.
Where is medical certificate?
Yes, I've already enclosed the. So medical, this post-traumatic disorder. So kindly see, this is this original medical document. So if not, then this honorable court may give some time more.
Some more time
Yes,
to remove the structure.
yes, because the person is not in the proper.
It's possible, no?
Yes, your lordship, further time may be granted, your lordship, no issue for that. Your lordship.
So this is serious, the sickness, mental disorder.
Matter is not over. BP has submitted that as per order of the learned, this court, the petitioner was directed to remove the RCC structure constructed by him on the premises of DRDA Godown. But he has not complied with the order of this court. CD is produced from which it reveals that it is reported by IO that the petitioner has not complied with the order of this court. Dated 16/8/23. So as the learned counsel for the petitioner wants to withdraw the case which is not accepted today, but the petitioner was given 1 week time or 2 weeks?
No, 1 week is not possible because
2 weeks?
3 weeks.
Okay.
My lord,
2 weeks.
one more,
2 weeks.
my
Yes,
prayer that the section 41 maybe, this is the latest judgment, this may be complied the police by police authorities. They have not followed, they have not given the,
you were in interim, so what's the problem in?
the police are, they're giving out disturbance. When he's the,
You were in interim, you have not appeared before the IO.
now that's why the IO, this morning also, he's given threatening.
There is no order to appear before the IO.
Your lordship, there is, the order is there, he has, his statement is recorded.
What is the statement?
Yes, your lordship, this is there, your lordship.
Wait,
My lord, previous order, last order, we have already submitted a bail bond of 20,000 and also given a statement also. That we have already complied the order. And as per the Anes Kumar also,
as per order of this court, within 7 days, you were directed to appear before the IO. So you
yes,
have
I've
appeared.
already complied.
Your statement was recorded.
Yes, already recorded.
So you were on interim.
Yes.
You were on interim. So.
So-
41(6), why it is required at this stage? So 2 weeks time?
2 week will not do, same 3 week time may be given because
2 weeks.
Upper Subansiri is a too long distance, no, from Itanagar to,
The petition is given 2 weeks time to remove the structure. Of the RCC structure. On the premises of DRDA Godown as per order of this court dated 16/8/23. I is also directed to submit report after 2 weeks.
Yes.
So you have to collect the report.
Yes, your lordship. Yeah, that CD may be returned, your lordship.
Huh.
Of life, DP of life.
Lordship is second time verification, Lordship.
Yes.
Lordship, this is having a matter of 302 and 201, Lordship. In this case, Lordship, in about 527 days, Lordship, I am behind the bar, Lordship.
521.
27 days, Lordship. The date of arrest is that, Lordship, 6/4/2022,
The
Lordship.
trial is going on.
Yes, Lordship, already the 4 evidence have been examined, Lordship.
You're from which place?
From Itanagar, Lordship, but naturally from the Bihar, Lordship. In this case, Lordship, only have a thing that, Lordship, I have a local person also there, Lordship. Here, Lordship, there is no any chance because, Lordship, our parents, relatives also are there, Lordship. Only having a thing is that, Lordship, we are long.
Is that it? Yes, Ms.
Lordship,
Patel.
not case study, is registered call for the LCR.
LCR along with the statement of the witnesses. Anything you have?
Lordship,
You
here,
found
Lordship,
it?
trial is going on and witnesses have been, the calling of the witnesses, their Lordship, the summons to the witnesses has called for Lordship. And due to some, absence of judge, this matter has been postponed to till the next day. Lordship, this is very serious matter, Lordship.
Identification is there.
Lordship, Lordship, where Lordship?
Yes, Lordship, may I, Lordship?
Yes, yes.
Lordship, in this case, Lordship, only if the sections of 302 is there, Lordship. Here, the main thing is that, Lordship, whether I'm going to present in the coming question or not, Lordship. Here, thing is that, Lordship, 527 days, Lordship, I'm behind the bar, Lordship. And here, Lordship, already 4 of the, and in this case, Lordship, please, Lordship, come to page number, Lordship. I have annexed the intimation copy on page number 11, Lordship. On page number 11, Lordship. It will start from 11. On page number 13 is a copy, Lordship.
11.
It's on 13, Lordship. This is a vernacular copy, Lordship. Right. Lordship, here, Lordship, an intimation, depending upon the intimation, Lordship, the entire anti-investigation is start, Lordship. And
Yes.
yes, yeah. In this case, Lordship, there is no any eyewitnesses present, Lordship. Or made on the basis of the 161 statement and the statement of the one of the co-accused, Lordship, my arrest was shown in this case, Lordship. And depending on the 161 statement, it fully matched with the co-accused number 2 and the 3, Lordship. Here the thing is that, Lordship, length of the detention, I'm 527 days, Lordship. I'm behind the bar. Already 4 of the one of the first bail application, Lordship, when this comes out that informant is not examined till now. But here, Lordship, 4 of the evidence is examined and none of the 3%, in this case, 3% all are behind the bar, Lordship. 3 accused is there, Lordship. But my pity, yes, 1, Lordship. Ramjan. Yes. Ramjan Ali, Lordship.
Accused is Ramjan Alam.
Yes, sir.
Main accused.
And Sahabuddin?
Sahabuddin is the father, Lordship, is wrongly printed there, Lordship. He is the petitioner in this case, Lordship. He is the father. Here, my submission is that, Lordship, already 4 accused examined, Lordship. And already 40 long trial is there, Lordship. 42 evidence are till examined in this case, Lordship. So, Lordship, in the meantime, only the things will concern whether I am able to present in the court in the proper time or not. Only this thing is there, Lordship. So, Lordship, there is a condition, any condition I will provide. I don't think so. Any objection comes out of prosecution side also there, Lordship. I will able to give the government service process also there, Lordship. Main objections which comes out in this case is that, Lordship, whether my appearance is in the trial court or not. 527 days, Lordship. So, Lordship, any condition, Lordship, if I have to give the government employee, Lordship, if I have to give 2 sureties, Lordship, I will level, Lordship. Second time I'm coming this case is that, Lordship. Very recently, Lordship, my sister husband expired, Lordship. And what happened, Lordship? She, Lordship, only I am the person and my father. He's the petitioner in this case, Lordship. He has a crossing the age of 60 years, Lordship. My presence is not present in my home, Lordship. Here comes out the Lordship. I'm able to give. If I'm not able to give the conditions, if I'm not able to fulfill the condition, whatever the court and on me, Lordship, then having the appearance in the trial court, Lordship, only having a section of the 302 and the 201, is there anything in Lordship? I must have not getting the benefit of the bail in this case. I'm not being released. If, Lordship, having the examination of the witness, Lordship, 4 till now, Lordship, 4 evidence examined, Lordship, no one, Lordship. No one in this case, Lordship, they implicated my name also there, Lordship. And in here, Lordship, intimation not given there, Lordship. Depending of the intimation, Lordship, entire investigation is started, Lordship. And now informant is also examined, charge is framed, evidence is still. Now, where is the problem, Lordship? Where is the problem, Lordship? Only having a thing that whether 161 is admissible in the court, Lordship. Depending on the statement of the 161, if they admitted their Lordship, admitted there, then why should the trial is there, Lordship?
Statement of the co-accused.
Yes, a statement of the co-accused, Lordship.
Lordship,
He was arrested.
Yes, Lordship, he was arrested.
Lordship, may I submit, Lordship? Lordship, during the Lordship production of the case diary, there it is reflected that the accused along with the co-accused, Lordship, they had the conspiracy to kill the Lordship SI, Lordship. This is very, Lordship, in his room, in his house, Lordship. And Lordship, after they have
occurred in the house of
Lordship, they have come, they have planned, Lordship. There's a planned murder.
Lordship,
And Lordship, they have executed the
yes, of course.
They have executed the plan meticulously and thereafter fled away to their native place. And when police team reached his native place at Bihar, he again fled to West Bengal. From the West Bengal, the police arrested him and produced him before the court below, Lordship. And Lordship, if Lordship doing the trial, Lordship, if he's given the bail, Lordship, he's every chance to Lordship fled away again, Lordship. And his Lordship,
bail was granted to him.
No,
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 Lordship.
Lordship.
No,
Because
Lordship.
during investigation also, Lordship,
Or
he,
during investigation?
yes, Lordship, because it's very, Lordship, difficult, the difficulty has been faced to the, Lordship, this investigation team to search him and produce here, Lordship. And Lordship, till the trial is, this commencing, Lordship, is yet not completed, and it's a witnesses stage is there, Lordship. So, Lordship, if this, at this stage, if the bail is granted, Lordship, this is, Lordship, really, Lordship, very heinous crime.
What are the evidence of the witnesses?
Lordship, only having a 1 minute of my submission, Lordship, only 1 minute, Lordship. Now, Lordship comes out, the police are doing a very good exercise, Lordship, they arrested me from their Lordship, but it is not reflected their Lordship when a single call is given to my father, Lordship, Shahabuddin is the petitioner of this case, Lordship. He is, as soon as possible, he visited in the police staff.
This
Lordship.
every chance
Lordship,
refusing
one-
liberty,
I-
Lordship,
in my
seriously,
defense,
Lordship,
Lordship,
every chance, Lordship, because he's the main accused, Lordship.
Lordship, how did we become main accused in this case, Lordship? In the 4 evidences, Lordship, examined in the court, Lordship, one thing comes out, Lordship, Saddam Hussein name is implicated. One of the identify him, Lordship. I am just going through the judicial things, Lordship. If the things should be held in open court. 4 evidences have been examined in this case, and this is on the basis of the intimation, Lordship, intimation. The entire thing is proceeding in done, depending on the 161 statement, Lordship. And the main thing should come, sorry, this case, Lordship, just only other thing is that no any eyewitnesses are there, Lordship. Only on the basis of that, Lordship, only on the basis of intimation, the trial is not finished, Lordship. Trial is also justice is equal to all, Lordship. Trial is not finished. 42, Lordship. Evidence are there in this case, Lordship. If I, in my trial, Lordship, in my trial period, Lordship, if I lost my, I'm a young person, Lordship. If I lost my all the age, Lordship, my simple submission is that, Lordship.
You have gone through the record?
Lordship, I have not gone to the record properly because today only I have seen the record, Lordship. Otherwise, Lordship, it may fix out 1-2 days after, Lordship, so that I gone to all the record properly.
Lordship,
Because this is, Lordship, as a appearance, Lordship, this is really serious case, Lordship.
Yes,
Lordship, it is plus.
Yes, because I'm just saying, because this is second time application, Lordship. I'm not going to think that. The single thing is that, Lordship, entire the case is that, Lordship, only having a statement of the 161, same statement, Lordship. Whatever the statement Saddam Hussein stated, how they implicate the case, how they, yes, Lordship, depending on that, Lordship, my statement is also made in 161, but my simple prayer is that, Lordship, length of detention and the long trial is waiting. If 2 or 3 evidences waiting in this case, Lordship, then it will be other things, Lordship. My humble submission is that I'm a young person. I'm a,
Day after tomorrow or tomorrow?
Lordship, day after tomorrow,
Lordship, I
Day
have,
after tomorrow.
Lordship.
Lordship, I have to come from the Guwahati, Lordship.
Okay. So somebody is representing you case from here?
Lordship, is it possible, Lordship, even tomorrow, Lordship? Then I will stay today, Lordship.
Tomorrow?
You know, on hurry up, Lordship.
Case is received, additional PP, please for. Please to take some matter tomorrow to go through the case diary.
This not case, there is LCR.
LCR, Lordship.
Yes, yes.
Hurry up, please.
Of like this.
It's difficult to, this thing is separate, all this thing. Item 9.
This so
On the last date, we filed Wakalatnama, Lordship.
Yeah, for the petitioner.
Yes, Lordship.
Because earlier some other council they here.
Yes, yes.
And thereafter they have taken so many dates on the pretext of substituting
What
the.
is,
council.
IA is for
IA is for vacating the interim order.
interim order.
Yes, passed by the Honorable Court. IA we have filed,
I is disposed of.
not yet disposed of. Since they have come, your lordship, the entire matter can be disposed of today. So let them begin.
Lordship, here in this case,
Yes.
here in this case, what had happened? There was an FIR lost at first, thereafter on 15/11/2022. The respondent number 3 had lost one FIR, which was registered as Itanagar Police PS case number 281 of 22 under section 120B, 467, 468, 471, 420 and 406 of IPC. Now thereafter, the police immediately after registration of this case went on to siege and freeze certain bank accounts of the accused and the bank accounts of few others who are related to the accused person. After freezing and seizing of those bank accounts in that case, very surprisingly, respondent number 2 had filed a Jimma application before the learned lower court. Now we have to, the whole scenario becomes like this, that the FIR has been filed by respondent number 3, but the petition has been filed for Jimma by respondent number 2.
Respondent number 2.
Respondent number 2. Now, Lordship, I'll take this honorable court to the copy of the FIR dated 15/11/2000, page number 29 to 33.
29.
29, Lordship. 29, and the type copy is on 33, Lordship.
33.
Yes.
33, yes.
Now,
It's not FIR. This is the
32, Lordship.
32.
32. Now here, Lordship, the FIR is filed by this respondent number 3 states, with due respect, I am to inform you that Sri Subhagya Kumar Boria, Amit Kumar and Sri Ahmad Ali Ayobi had conspired together, induced me with false documents and forged valuable securities on pretext of awarding a contract work and cheated me of rupees 4 crore 15 lakhs only. That previously I have been in search of contract work to execute the same under Messrs. S&Y Builder and Developers. That, sir, I came across one Sri Subhagya Kumar Boria of Messrs. Henderson Construction India Private Limited, who introduced himself as an important member of the said company. In the last week of October 2022, he had introduced me to Mr. Amit Kumar, an official member of NHIDCL Delhi. Both of them had introduced me to Mr. Ahmad Ali Ayobi. Now, Ahmad Ali Ayobi is the petitioner, Lordship, here, who was reportedly the managing director of Messrs. Henderson India Private Limited. After that, they had induced me to pay rupees 4 crore 15 lakhs on pretext of awarding road construction contract work of grazing Ladda to Basai from KM 0.00 to KM 35.260 in East Kameng district, Arunachal Pradesh. So, trusting their assurances, I had made payment on 5/11/22 of amount of rupees 3 crore and rupees 1 crore 15 lakh, total rupees 4 crore 15 lakh from Bank of Baroda, Itanagar branch into account bearing number such and such of IndusInd Bank, which has been given to me by the 3 culprits. After the payment, all the 3 suspects started making lame excuses regarding giving some important contract documents to me and started avoiding me. So upon being aggrieved of the said offenses, this FIR, Lordship. Now here in this FIR, this respondent clearly states that he has made all the transactions. He has paid the money of rupees 3 crore and then 1 crore 15 lakh, etc., etc. Now, Lordship, if that is so, how come respondent number 2 has claimed the money in the Jimma application? That is the question on, Lordship. Now, let us go to the
Jimma petition is allowed.
Jimma application was allowed, filed by respondent number 2, Lordship, and that order is at page 24 to 28, Lordship. Just let me. The order starts from page number 24. 24. The learned lower court order. Now, this is a very detailed order where the learned lower court has passed, and this is under challenge here, Lordship. The learned lower court says on that this Jimma application is filed under section 457 CRPC. So case, the allegations in the FIR dated 15/10/22 received from one Kali Rezizu is that such and so, which we read. The counsel for the applicant submitted that the instant case is pending and investigation is still on. That the applicant is the proprietor of firm Messrs. S&Y Builder and Developers. The accused person Ahmad Ayubi, being the MD of Messrs. Henderson Construction India Private Limited, induced the applicant to transfer a sum of rupees 4 crore 15 lakhs in the pretext of awarding road construction contract work. The said amount was deposited in 2 installments of 3 crore and 1 crore 15 lakhs. Thereafter, however, later on, it was found that the bank guarantee shown by the accused person was fake. During the investigation, the IO of the case frozen the account of Mrs. Henderson Construction India Private Limited and found only rupees 3 crore 60 lakhs left in the account. Further, it is prayed that the IndusInd Bank, page 25, next page, Lords. Further, it is prayed that the IndusInd Bank in which the accused person firm holds the account be directed to transfer, release the amount of 3 crore 60 lakhs. Learned APP has submitted that the report of the IO confirms that the applicant is the proprietor of Messrs. S&Y Builders. And the amount of rupees 4 crore 15 lakh was transferred from her firm's account. Now, IO is confirming that the amount has been transferred from her account, while the FIR says that the amount was transferred by respondent number 3, who has lost the FIR also. Thereafter, further, that the said money is not, and what the IO has reported there in the JIMA application, the further that the said money is not required for the purpose of further investigation. Therefore, she has no objection if the money is released and transferred back to the account of the applicant's firm. So the police has given a clean cheat by filing the report before the London lower court that the amount is not required, that the amount was transferred from the account of respondent number 2, and that amount may be given to her because it is not required for further investigation. Basing upon all these, the London lower court further held, upon perusal of the report of the IO, it is seen that the applicant Srimati Lika Yapi is the proprietor of Messrs. S&Y Builder and Developer and holder of account number such and such. Also seen at annexure 1 of the application, the trade license bearing number such and such issued by the officer of the Commissioner Itanagar, wherein it is seen that the applicant is the proprietor of Messrs. S&Y Builder and Developer. Also seen the transaction details at annexure 3 of the application, wherein it is seen that an amount of rupees 3 crore and 1 crore 15 lakh was transferred through RTGS from the account of applicant's firm. The record further reveals that the amount deposited into the account of the firm of the accused was further disbursed into 12 different accounts. During the course of investigation, the IO of the case seized and froze the 12 accounts. The same has been reported to this court and the seizure memos have been produced before this court. As per the report of the IO on 5/11/22, amount of rupees 3 crore and rupees 1 crore 15 lakh were transferred from the account bearing such and such to such and such account number. Further, in the next para, Lordship, the IO of the case has stated that the said money in the frozen accounts of the accused person is not required for further investigation and that the release of the money to the applicant at this stage will not hamper the investigation. Upon perusal of the case diary containing the bank transaction details, this court is satisfied that there exists sufficient material to show that the amount in the bank account of the Hasneen Akhtar, Sadia Khatun, Messrs. Henderson Infracom, Saubhagya Kumar Boria and Ahmad Ali Ayubi are connected with the alleged offense. As per the entries in the bank account transaction, it can be seen that the accused person Ahmad Ali Ayubi had transferred the amount from his firm, Messrs. Henderson, to said account right after the applicant's firm transferred the money to the account of the accused person's firm. Therefore, this court is of the opinion that the interim custody of the seized amount be handed over to the applicant's firm, Messrs. S&Y Builders. It is seen that from the personal account of Ahmad Ali Ayubi, money was transferred to 4 different persons, namely Jubair Ahmad, Sahid, Qadar Khan, Pathan, Sabhan, Parveen, and Siddiqui Ahmad. However, the said persons are 4th party in the transaction chain. Therefore, at this stage, I do not consider it appropriate to pass any order for transfer of money from their account. Considering the fact and circumstances of the instant case, this court is of the opinion that the interim custody of the seized money be handed over to the applicant as follows. Now, the whole disbursement has been mentioned thereafter as to from which account, how much money would be delivered. Now, very surprisingly, Lordship, when this matter was being dealt in the London lower court, when this JIMA application was filed by a third party respondent number 2 before the London lower court, we were not made a party. We have not been heard before passing this order of JIMA application in the London lower court. Number 1. Then, Lordship, we come to
against the order of 12/1/22. Against this order, you have filed this petition.
yes. Then, Lordship, first, the ground that we have not been made a party in the London lower court. Then, Lordship, what we beg to state before this honorable court is that whether bank accounts can be seized, whether the police has the authority to seize the bank accounts or not, Lordship. For if under section 102 CRPC, where the seizure power has been given to the police, Lordship. We replace the judgment of the Honorable Guwahati High Court.
Yes. Please.
Lordship,
102, yes.
Lordship, may come to case 2 of this. Under section 102, the police officer has to report the seizure to the magistrate concerned. And if the property seized cannot be conveniently transported to the court, the police officer may give custody thereof to any person on his exercising a bond undertaking to produce the properties before the court, and when required. Section 451 CRPC provides for disposal and custody respecting the property produced before any criminal court during inquiry or trial. Section 457 CRPC provides that whenever seizure of property by any police officer is reported to a magistrate under section 102 CRPC, and such property is not produced before a criminal court during inquiry or trial, the magistrate may make such order as he thinks fit respecting the disposal of such property or delivery of such property to the person entitled to possession thereof. On reading of section 102, 451 and 457 CRPC together, it indicates that the word siege used in section 102 CRPC means actual taking of possession in pursuance of legal process. Therefore, prohibiting a bank with which the accused has an account and a locker not to pay any amount out of the account of the accused to the accused and not to allow the accused to take away property from the locker is not seizure under section 102 CRPC. As the seizure as contemplated under section 102 CRPC is an act of taking possession of the property, in fact, and as such, no such order can be passed by a police officer. Now, normally, when the police investigates a case, Lordship, they just write a letter to the concerned bank, and then thereafter the bank freezes the account, and the police has to, since it is provided under 102 that they have to prepare the seizure list, etc. So the police writes that seizure list and takes the witness's signature there, and they submit before the London lower court for purpose of marking scene. So that process was definitely followed when this bank account were seized. But this clearly says, Lordship, here that bank accounts cannot be seized. This Honorable Guwahati High Court ruling very clearly states this. So on that count, first of all, the seizure itself of the bank accounts of the accused is under challenge. That seizure cannot be made under 102 CRPC. Moreover, while Lordship will see the seizure list. We have obtained the copies. This is the seizure list which has been which was prepared after the seizure of the bank accounts. There are 3 numbers of seizure list we have produced before your Lordship. Here, Lordship will find in the witnesses column. In the witnesses column, only one witness has been signing in the witness column.
Which one?
And in the seizure list, in the witness column below, only one witness has signed in the witness column. There is no requirement of 2 witnesses, Lordship, always. But in all the seizure list, the police has taken the witness of only one witness, and that 2, he is the complainant of the FIR. That is respondent number 3, who has filed the FIR, Lordship. He has been signing, marking himself as a witness. Now it is mandatory under section 100 subclause 4 of CRPC, that before making a search under this chapter, the officer or other person about to make it shall call upon two or more independent and respectable inhabitants of the locality. Lordship, when the police was seizing the bank accounts, when they went to the bank, whether they did not found any independent witness to mark a signature upon the seizure list, they could not found two witnesses. They only found only one witness, and that one witness is also the
Is there
complainant.
any separate order for seizing of the bank account?
Lordship,
Is there any separate order for seizing of the bank accounts?
separate order by whom? I didn't think so.
That is.
No order has been passed. No, the court, any court has not passed any order for seizure of. Police on 15/11/22, the FIR was
Police
lodged.
has approached before the bank, that
Def-
to seize the bank account and the bank account.
Yes,
On the
yes.
basis of the report of the.
Yes,
Bank account has been.
yes, yes. That much exercise was done by the police. There is no order by any court, etc. Nothing. Nothing has been taken. So, Lordship, on this count also, that the whole seizure goes away. It is vitiated from the day of the seizure itself. Since number one, bank account cannot be seized. Number two, even when in the process of seizing, when you have seized, you have not followed the mandate of section 100 subclause 4 as well. As because it requires to mark two witnesses' signature, the police has not been following that too on. Lordship. The money was transferred to my account, Lordship. That is an admitted position. That is, we do not say that we have not received the amount. But when we that has been deposited to our bank, or thereafter that has been transferred to the several other bank accounts. But the filing of the JIMA application by the respondent number 2 itself is illegal, Lordship. Number one. Then we were not made the party there at that aspect is also there. Then
Money has been transferred to your bank account.
yes. Money was transferred to my bank account.
Entire money, that is for.
4 crore 15 lakhs. We agree, because Lordship, why it was transferred, how it was transferred. There was an MOU between me and the this respondent number 2. And because under that understanding, the money was transferred to me and the works were about to start. But just after transferring of the money, after 1 week, after the transfer, within 1 week, this FIR was lodged that I have been misappropriating, etc., by that allegation. And beforehand, that there was in the memorandum of understanding, there was a clause of arbitration clause. So we have already sent the letter of arbitration, that since there is certain disputes between us, so that matter may be referred to arbitrate. But not taking the recourse of the arbitration, the matter was polarized completely into criminal proceedings, and one after another FIRs were lodged. There were 3 FIR lodged against me, one after another, 2 pending in Itanagar PS, the another one pending in Panging PS, and for the same transactions, all this money transactions itself by with me. Lordship. It cannot happen, Lordship, that in the FIR on the basis of which this whole criminal proceeding has initiated, that in the FIR someone says that I am transferring, I am giving, I am entering into the arrangement, and then somebody else comes to the honorable court and files JIMA application, and the impugned order which has been passed by the learned lower court somewhere or the else has decided the whole case, Lordship. Even before the investigation has been completed by the police, even before the charge sheet has been filed or a final form has been filed by the police, the London lower court has decided as to yes, that respondent number 2 is the owner of the property. Because until and unless the ownership of any property, movable or whatever property it is, Lordship, until and unless it is decided that who is the owner, the JIMA cannot be given in either interim or absolute, Lordship. Here, the London lower court has very categorically reached to that decision that the money belongs to such and such person, and it has gone from her account, and it seems that the money was transferred from the accused, from the account of the accused to different other accounts, bank accounts. So in that manner, the whole scenario is this, that on that day, by that impugned order, I have been only not put behind the bar, but I have also been convicted as on today by the London lower court itself. Because this is the whole piece depends upon the transaction of the amount and whether it was transacted on the basis of false forged documents or whether false assurances or promises. So Lordship, on these grounds, we are before this honorable court for setting aside the impugned order, Lordship. Anything to reply? I'll reply there, Lordship.
Yes, please. Yeah, for the respondent,
2 and 3.
respondent 2 and 3.
2 and 3. Basically, my lord, what is their contention in their revision petition is saying?
2 and 3.
2 and 3. Actually,
3 is the informant, 2 is the Jimma, the petition.
Jimma applicant, the owner from whose account the money was duped and then it was transferred to the account of this petitioner. So partially, my lord, the citation which my learned brother has placed, I think that is out of context. Because your lordship may kindly go through the revision petition. No issue, no statement that the seizure was not properly done. Kindly come to page, dear petition. That's why I was so like.
Petition?
Page number 18.
18.
The grounds they have taken in this revision petition. Even in the entire averments also, it is completely and absolutely silent regarding the seizure that was made, or they have never questioned about the making of seizure. Kindly come to page 18, the grounds they have taken.
Yes, that is the grounds.
Grounds, my lord.
Yes.
A, for did the learned court below fail to apply the judicial mind while passing the order dated 12/1/2023 in Jimma number 50 of 2022. As such, the same is liable to be set aside, interpreted, modified. B, for that there are material contradiction and disputing claims made by the respondent number 2 and 3. What they are saying, my lord? FIR is being lost by respondent number 3, saying that that amount belongs to him. And the Jimma application, this respondent number 2 has come and filed the application. That we have like giving contradictory statement. That is their stand. Respondent number 2 and 3, which makes it clear that the respondent number 2 and 3 in connivance has misled the entire issue to get favorable orders and cause prejudice to the petitioner. Therefore, the order dated 12/1/2023 passed in Jimma number 50 of 2022 is bad in law. As such, the same is liable to be set aside, interfered, modified. C. For that, while disposing of the Jimma number 50 2022, no notice has been served to the petitioner, thereby deprived the petitioner from his legitimate right of being heard, which clearly amounts to violation of natural justice. Therefore, the entire proceeding of the Jimma number 50 of 2022 is bad in law. Therefore, the order dated 12/1/2022 passed in Jimma number so and so is liable to be set aside, interfered, modified. D. For that, the respondent number 2, while prepared the Jimma petition, being Jimma number 50 of 2022, neither made the petitioner as party respondent nor made the improvement of the FIR dated 15/11/2022 as party respondent, that is respondent number 3. As such, the order dated 12/1/2023 was passed in their absence, which amount to dereliction of judicial powers of vested by the procedural law holding the field. Therefore, the order dated 12/1/2022 passed in Jimma number so and so is able to be set aside, interfered, modified. E, my lord. For that, while passing the order dated 12/1/2022 in Jimma number so and so, the Judicial Magistrate Plaskas Capital Complex at UP Papumpari District, Arunachal Pradesh, miserably failed to deliver justice following the natural law principle, and as such, the impugned order is bad in law, liable to be set aside, and so on. So, F, my lord. For that, while passing the impugned order, the learned court below committed error of law as well as of facts. Therefore, the order dated 12/1/2022 passed in Jimma number so and so is bad in law, as such, the same is liable to be set aside. G. For that, in any view of the matter, the order dated 12/1/2022 passed in Jimma number 50 of 2022 by the London Judicial Magistrate Plaskas Capital Complex at UP Papumpari District, Arunachal liable to set aside in quest. Now, my lord, no any single ground saying that the seizure that was made was not done as per the procedure. That making of seizure is never put to challenge by this petitioner. In this revision petition, their claim is simply, my lord, that they have been not made as a party in my application, firstly. Secondly, when the FIR was lodged by respondent number 3, saying that he has paid the money amounting to rupees 4 crore 15 lakhs, then how come this respondent number 2 comes and files Jimma application? So only these two issues, my lord. Now, my lord, for delivering interim custody of any property that is seized during the period of investigation, that is the complete discretionary of the learned judicial magistrate, my lord. And now, my lord, if we read section 102 together with 457, my lord, there is no any such provision that while deciding for any custodial or any interim order to be passed, that the accused person or other person, they have to arraign as a party respondent. My lord. Let us come to 102, my lord, CRPC. My lord, by way of Amendment Act 1978, subsection 3.
Subsection 3.
It was brought into this 102. Every police officer acting under subsection 1 shall forthwith report the seizure to the magistrate having jurisdiction, and where the property seized is such that it cannot be conveniently transported to the court. Like in our case, because the account that is frozen, my lord, that is not tangible one. So that cannot be conveniently produced before the magistrate. So in such a situation, my lord, the seizure officer, the investigation officer has to report to the magistrate that it cannot be conveniently transported to the court, or where there is difficulty in securing proper accommodation for the custody of such property, or where the continued retention of the property in police custody may not be considered necessary for the purpose of investigation. He may give custody thereof to any person on his executing a bond undertaking to produce the property before the court as and when required, and to give effect to the further order of the court as to the disposal of the same. So requirement is that, my lord, immediately after seizure, report has to be made to the magistrate concerned that we have made the seizure, but then this is inconvenient to produce the seizure item before this honorable court. Now kindly come to 457, my lord, CRPC. Procedure by police upon seizure of property. Whenever the seizure of property by any police officer is reported to a magistrate, that is in terms of 102 subsection 3, my lord, to a magistrate under the provision of this code, and such property is not produced before a criminal court during an inquiry or trial, the magistrate may make such order as he thinks fit, respecting the disposal of such property or the delivery of such property to the person, my lord, entitled to the possession thereof, or if such person cannot be ascertained, respecting the custody and production of such property. So now, if we read these two sections together, my lord, and thereafter the impugned order, my lord. Let us come back to impugned order, my lord. That is in my affidavit at page 49, my lord. My brother has read out up to page 51. Kindly, my lord may come to page 52.
Yes.
Second paragraph, my lord.
Yes.
Considering the facts and circumstances of the instant case, this court is of the opinion that the interim custody of the said money be handed over to the applicant as follows. So many accounts, my lord. Because during the money trial, my lord, it is found, not disputed even, that this petitioner immediately after receiving the amount, that is 4 crore 15 lakhs from respondent number 2, has transferred such amount to such bank accounts. Next page, page 53, my lord. Second para. The manager of the respective banks are directed to transfer the amounts from the account holder of their banks as mentioned above to the account of the applicant. Following terms and conditions are imposed on the applicant. This is very important, man. Number 1, she shall execute an indemnity bond at the rate of 3% per annum against each amount from serial number 1 to 7. That we have complied, my lord. So this is a temporary arrangement. Even if tomorrow it is decided in the future that the money belongs to someone else, then I have to return it with 3% interest per annum, my lord. Now, condition number 2, my lord. Roman 2. On conclusion of trial or at any point during trial or as directed by the court, the applicant shall indemnify the amount along with interest as mentioned above. On execution of the indemnity bond, the interim custody of the amount shall be handed over to the applicant by transferring the amount as directed above. Accordingly, the instant JIMA application is disposed of on being allowed furnished copy of this order to IO for information and necessary action. Thereafter, my lord, kindly come to page 54 onward, Annexure 5 series.
54.
54. So this respondent number 2, in compliance of that order, has executed the indemnity bond also, by in respect of those amount. 54 to my lord, page 67, my lord. In respect of 7 accounts defreezing in respect of the amounts that was transferred to her account. And after, my lord, this indemnity bond, out of 7 accounts, my lord, 6 accounts already the amount is transferred to the account of the respondent number 2, that is JIMA applicant. But only 1 account that remains to be transferred. In the meantime, they prepared this revision petition and there is a stay order. Stay order. Therefore, my lord, I have filed the IA on the ground that since I have already executed the indemnity bond, and by whatsoever means tomorrow, if I have to return the amount with 3% interest. So that interim order, stay order may be kindly vacated. And the amount that was given in my favor in JIMA application, that may be,
It is for the IA.
that is in the IA. So, my lord, conflicting statement in the FIR and JIMA application cannot be the ground to my humble understanding to law, cannot be the ground to interference with respect to the impugned order that was put to challenge in this revision petition. That is my first leg of submission, my lord. Secondly, my lord, as we have read out section 102, subsection 3, together with 457 of CRPC, there is no mention that the magistrate, while exercising his or her discretionary relief in context of like temporary arrangement for the custody of any property, that the party has to be made against or to the accused whose account is likely to be defreezed. And my lord, my learned brother has again read out section 100 subsection 4, saying that in any seizure there has to be 2 or more witnesses. But then if we read section 100 subsection 3, that has to be read together with section 4. That is in respect of any article. Any article means that should be tangible, my lord. But in this case, bank account is not tangible. Therefore, I read out section 102 subsection 3 also, my lord. And now they are saying, while filing the bail application also, they are not denying that they have received the amount. They simply says, we have made an agreement, and then if anything has to be done, recourse has to be through the arbitration. But how
Agreement,
can
where is agreement? Agreement is there.
agreement is there?
Where is agreement? The money has been transferred on the basis of an agreement.
On the basis of an agreement. Basically, the very basic facts, my lord. This petitioner, my lord, representing himself as a director of a company, promised us, both respondent number 2 and 3.
2 and 3.
2 and 3, that you will be provided for 100 crore of construction work. So you deposit rupees 4 crore 15 lakhs to secure the bank guarantee that we have, that we will be submitting to the NHIDCL, that is National Highway Development Corporation Limited. So on believing that he is having genuine bank guarantee, we have transferred the amount. But later on, it was found that their bank guarantee, it was fake. And then, despite of repeatedly like trying to contact them, they fled away from Itanagar. And this petitioner, my lord, kindly come to my affidavit. He is a habitual offender of such similarly situated cases, my lord. That is, he is
Some other cases are also pending.
so many. He is to all Arunachali, he is promising that I'll be providing you such and such contract work. You pay me this much of amount. Therefore, there are 3 FIRs which my learned brother has said out of same transaction. That is not correct. In my affidavit in opposition, I have annexed all those FIR. That is by separate person, 3 FIR. Of course, one is by this respondent number 3.
In your affidavit, you have stated so.
I have stated, my lord. So therefore, my lord,
Number?
page number, my lord, 68 to 74, my lord.
68 to 74.
68 to 74. This is, I believe, the second FIR after our FIR. This is lodged by one Sri Biri Kakum, ESS sector, Itanagar. Herein also the total cheated amount is, my lord, 64 lakhs 36,000.
One FIR is page 69.
69, my lord. Yes, my lord, 69. 71 onwards, my lord. This is of dated 26 March 2023.
26-3, yes. 26.
FIR against one Sri Ahmad Ali Ayubi, Sri Soil Akhtar, Sri Ranjan Kumar Shah and others. And this is also registered, my lord. Itanagar PS case number 73 of 2023 under section 120B 420 506 IPC. Another FIR is at page 75, my lord.
75.
And
Parjin, no?
yes, my lord. Takitalo, and very interestingly, they have moved petition today itself. Item number 21 for questioning of this FIR. This is also again same nature of offense, my lord. 1,19,96,000 amount has been cheated from this informant, Sri Takitalo, and this case is also registered as Pangin PS case number 9 of 2023. So now, my lord, my respectful submission, my lord. When this Jimma application it was filed, the learned judicial magistrate past class had exercised judiciously, arriving at the conclusion that during the money trial, it is clearly found out that the account that was transferred from the applicant stroke respondent number 2 herein to the account of the petitioner, that is amounting to 4,15 lakhs, has been disbursed to some other account, and that was frozen during the course of investigation. Therefore, prima facie founding that this applicant, respondent number 2, is the owner of that property, has
And
temporary.
3 is related.
3 is the informant.
Informant, any relations with this?
He's my worker. Kindly come to my affidavit, my lord. First page, my lord.
First page.
Affidavit in opposition, I Srimati so and so, thereafter number 1, my lord. That I have been implemented as respondent number 2 in the instant criminal division petition number 3 AP 2023.
Affidavit in page number here, that is
Uh,
affidavit in reply.
Affidavit, no, affidavit in opposition. Affidavit in
Page number?
reply they have filed, page number 1.
No. Here in this-
Affidavit in opposition filed by respondent number 2.
Affidavit in opposition in reply. Affidavit in reply.
Reply is-
Filed by the petition.
Petition.
This is affidavit in opposition. Okay. In IA, you have filed this on IA.
I also in my affidavit in opposition to the revision petition also, my lord. Revision petition, affidavit in opposition.
In revision petition, I didn't find it in the revision petition. In IA, that is one.
In main petition, I have filed affidavit.
This is IA, revision petition.
Respondent number 2. Page 1 itself, my lord. Paragraph 1, my lord.
Paragraph.
That I have been implemented as respondent number 2 in the instant criminal division petition number so and so. And the respondent number 3 is the employee representative of my palm MS SNY builders and developers. I have received a copy of revision petition. So that is repeatedly, my lord, we are saying that he is the representative of my firm and he is my employee. As because this person, they have personally directly contact with my employee, respondent number 3. Therefore, he had lost the FIR. And my lord, FIR is not encyclopedia.
Any documents you have filed that you are the owner of this SY builders?
My lord, in Jimma application, it is reflected Even my trading license is there, my lord, in the Jimma application.
Please now.
Page number, my lord. May kindly come to their petition, my lord. It is there. Revision petition, revision
Revision
petition, main
petition, yes,
revision.
revision.
It is there. It pays, my lord, 93. This is the trading license, my lord. And it was taken into consideration while passing the impugned order also, my lord,
Page 93.
of revision petition, my lord. Criminal revision petition. Page 93, my lord.
Is it trade license?
Trading license, my lord.
Page 93, this is page 93.
They also behave well. Page 93.
93, lordship.
93.
93 is 93 something is
Revision petition, my lord.
revision petition, yes. This is revision petition. Page 93. Contents. Documents they have signed, contents.
Revision petition. The one, page 93. Yeah. And one more factual aspect, my lord. That is subsequent to filing of this revision petition, my lord. The wife of this petitioner, Srimati Sadia Khatun, she has filed Jimma application.
Fine.
She has filed Jimma application before the learned JMFC, claiming the one amount of rupees 80 lakhs that is not yet transferred to the account of applicant.
Where is the petition? This
No, not,
record is false.
no, my lord, record, it was not called.
Yes, on 26th May. 26th July.
This order.
Yes. Status report.
Okay.
Jimma application number 7 of 23, my lord. It
They
is
submitted
pending.
in the record. That is in the
No,
record.
it is not there in the record.
CS has not been called for it.
will be not required in this case. This is separate application, my lord. Subsequent to filing of this revision petition, they have filed one Jimma application. So likewise, my understanding to law, my lord, if any of the account holder is aggrieved that their amount has been defrozen and transferred to the account of this petition, respondent number 2, they can move a proper application before the London JMFC UPA, my lord, like this Srimati Sadia Khatun has done. So accordingly, that will be considered as because the amount which was given to me, it is, my lord, temporary arrangement only. And that is also, my lord, subject to the condition that I have to pay interest, 3% interest per annum upon that amount. If tomorrow this amount has to be given to some other person as the actual owner. So therefore, your lordship, my humble submission may not interfere with this impugned order. This revision petition may be dismissed with a direction. If any parties agree, any bank account holder, they can approach the London JMFC UPA. Highly obliged.
Lordship reply just on 102 and 457. Lordship, this is a judgment from Delhi High Court, passed by Delhi High Court. Delhi High Court, para 12, Lordship. Again, even if the provision of section 102 are held applicable, the respondents have not followed the requirement of this section. Reading that provision, by adapting into the case of seizure of a bank account, the police officer should have done two things. He should have informed the concerned magistrate forthwith regarding the prohibitory order. He should have also give notice of the seizure to the petitioner and followed her to operate the bank account subject to her executing a bond undertaking to produce the amount in court as and when required, or to hold them subject to such order as the court may make regarding the disposal of the same. Now, this has not been followed while the police has seized the bank account. We were not even then informed, Lordship, when the account was seized, what to speak about when the order of the Jimma was passed. This was not done. Even a copy of the prohibitory order was not given to the petitioner. The police did not seek the directions of the magistrate trying the offense. So here in this case also, the police has not moved to the London magistrate for seeking any direction, Lordship. Similarly, not only that, when the petitioner herself approached the magistrate who was trying the petitioner's husband under the Official Secret Act, her request to be allowed to operate the account was opposed by the police, contending that the bank account was not case property and that the petitioner's remedies lay elsewhere than in the court of the magistrate. The magistrate accepted the plea of the police and dismissed the application of the petitioner and directed to seek remedy elsewhere before the appropriate authority. The petitioner, having lost before the magistrate, had no other recourse except to file a writ petition praying for the setting aside of the prohibitory order. Now, in the light of this para, Lordship, similar situation has arisen in our case also. We are here, Lordship, to look after whether the seizure was legally done, first of all, and whether the Jimma order was legally passed or not. That much aspect we are looking into in this criminal revision application, Lordship. Now, after this, Lordship may also have another citation by our own Honorable High Court, Pranab Kumar Ghosh versus CBI. Here, Lordship may come to para 6, Lordship. It is contended in the present petition that the petitioner in his individual capacity, Ghosh Brothers Motors Private Limited and other group of companies maintained various accounts in the ICICI Bank Beltola branch Guwahati, and day-to-day business transactions in the aforesaid accounts are done for business purpose. The petitioner came to know as a matter of surprise from the banker that the accounts had been freezed by the official of CBI, ECB Guwahati, and he was not informed about the reason of freezing, nor the banker furnished any information in this regard. The same thing had happened to us also, Lordship. We were also not informed. Then Lordship may come to para 23. Para 23, Lordship. So far as the other compliance of the provision of section 102 CRPC, it reveals that there is no evidence to show that the petitioner was served any notice about such search and seizure by the investigating officer, and their assertion that they have been verbally informed is of no substance, as the petitioner came to know all about the seizure of accounts after several days of seizure from the bank on the query made by them when they are not allowed to operate the accounts. Case diary is silent on all about such compliance. Furthermore, there is another blatant violation of the provision of section 102 subclause 3 of the CRPC. Under the said provision, the matter of seizure is to be reported to the magistrate having jurisdiction forthwith. But from the matter on record and even from the impugned order, it reveals that IO has informed the court about such seizure on 17/8/21 only after filing of the petition by the petitioner for defreezing the account on 12/8/21. It is evident that although the search and seizure was made on 22/6/21, but same was not reported to the court forthwith or its own notion, but only when the court sought for the information on the basis of the petition filed by the petitioner. The same reply of the IO cannot be regarded as a mandatory compliance under section 102 subclause 3 CRPC. Para 24, Lordship, last line. In view of the legal proposition as has been discussed above, the condition of section 102 subclause 3 CRPC is to be strictly followed by the IO. But in the instant case, the mandate of law has not been followed. The same thing has happened to us also, Lordship, in this case also. The result of the seizure of large number of accounts is manifold. In one hand, it has the effect of serious consequences in the entire business establishment of the petitioner. On the other hand, the financial difficulties faced by the employee under the establishment apart from the running of business of the petitioner cannot be denied. As a corollary of all the above, petition is allowed. Order of learned trial court dated such and such is hereby set aside with direction to the investigating officer to defreeze the 15 bank accounts as above in ICICI Bank and 2 bank accounts in Bank of India. In light of these citations of Honorable Guwahati High Court and even the Honorable Delhi High Court, which we have cited today before your Lordship, we find that the provisions has not been followed as it should have been. And Lordship, while my learned friend was submitting, Lordship was also curious to know one thing, that whether respondent number 2 and 3 have, what is the relation between them? Though in their affidavit, it has been stated that respondent number 3 is the employee of respondent number 2. But to that effect, there is no document, Lordship. The document which has been shown is that document, which is the trade license, that respondent number 2 is the owner of that Messrs. S&Y developers. But there is no relation between 2 and 3 shown on record, Lordship, until now. So, Lordship, on this situation, this criminal revision may be allowed, Lordship.
Yes, additional PP. Yes. CD is available, no?
CD, earlier code for now, it is a status report.
Status report.
Status. As on 26 July 2023. Thereafter, adjournment after adjournment. And now, the status of the investigation at present state is not in my knowledge. As per the last status report, investigation is still pending and the petitioner is absconding. Even Honorable Apex Court rejected the AV applications.
Apex Court.
Apex Court. Interim was granted by this court, and interim was AV was rejected, and interim vacated. But as per status report, it is in the report of the court. It is on the record.
What about section 102? Anything is there in status report?
No, it is not there. So we need LCR regarding 50 of JIMA applications. That proceeding, LCR was required to accept whether there was compliance of 102 or whatever.
LCR required.
LCR required regarding JIMA proceeding. And as per status report, it is primary established against this petitioner.
Yes.
Primary case is established against this petitioner.
That is different issue. Charge sheet is not yet submitted.
Not yet submitted. That's why
Your lordship, learned court below, Magistrate JMFC, passed this interim order to transfer back to
The
the.
thing is there, whether IO has followed the section, the provision of section 102, it is not there. The CD is required.
CD is, no.
LCR, not
LCR.
LCR. Not
LCR.
LCR case diary. Case diary.
Yes. Petitioner even alleged that notice was not served.
Served, yes.
Yes, that's why LCR is required.
LCR and
And
including
CD,
case
yes,
diary.
yes,
also.
exactly. CD, updated CD.
After hearing all these things. Okay.
If you can copy.
Yes.
May I say something? Yes, earlier also I have objected, my lord. When in your revision petition regarding that procedure of seizure, you have ever nothing. Then how do you, in such a stage of argument, hearing, you raise certain issues that is not your pleaded case? Therefore, let us leave aside the part of the process of seizure, what is that order that is done correctly or not. And this revision petition has to be considered, if it has to be considered, this has to be based on their pleaded case. Therefore, I have submitted.
He
my
has raised the point that is following the 102.
My lord,
So-
then they have to file separate petition for that.
That is different issue. Yes, so we have to check the case diary whether IO has followed all these things or not.
My lord, without having any pleadings in the revision petition, if we,
Yes, sir.
honorable court goes on to deal with the issue and kindly see their grounds, kindly see their prior portion of the revision petition. Though these are technical,
The petition is.
even that seizure portion, certain documents today only they have submitted before this honorable court. It is not even annexed in the revision petition. So how do we answer on that also, ma'am? If CD has to be, no, if LCR has, record has to be called for, that has to be from the learned JMFC court,
Yes.
pertains to this revision petition. But if they raise some other issues regarding seizure, I think they have to amend this petition or they have to brought another revision petition against the procedure of seizure. That was never questioned in this
I have to
revision.
pass the order. So I have to check all these things, whether submission of this, yes, please.
With all due respect, Lordship, in our grounds column, though specifically 102 or 457, those words are not mentioned. But in our grounds column, para A, it says, learned court below failed
Please,
to apply in criminal petition, ground column, page 18. Page 18. We agree and admit that specifically those points has not been written down, but grounds column A,
yes.
learned court below failed to apply the judicial mind while passing the order dated such and such in Jimbanama. Then we come to page 20, para E. Para E. For that, while passing the order dated such and such in Jimma number such and such, the learned JMFC Capital Complex miserably failed to deliver justice following the natural law principle. As such, the impinged order is bad in law. Lordship, these words and these grounds covers the whole scenario of the law points, not on facts. On facts, we have to come very specifically. But for dealing with the law points of section 102 CRPC, the mandate of the law, whether followed or not. So that amendment is already there, Lordship.
Now, my lord, how do you substantiate these grounds with facts? Where is the averment, single averment in your revision petition saying that procedure it was not followed?
Anyway, there is a submission, so. if I pass the
Anyway,
order,
one
cities-
thing, my respectful submission, my lord. I'll also place some judgment. And other than that, because my lord, tomorrow your lordship may not be misled. If it has to be
It's
disposed.
better to wait for the case diary and say on that day, you will. play
On
for
that day,
the
I'll
case.
submit a decision of Honorable Apex Court wherein it was held. I have gone through somewhere, just now I was looking for that. That notice is not required while freezing,
Okay.
invoking
You will
subsection
fix all
Q.
these things on that day. Yes, please. Mr. Additional PP.
Meantime, my
the
lord,
date will be
meantime, my lord, may I pray this IA may be disposed of by vacating the interim order Yes, because that lady, Sadia Khatun, she has filed a JIMA application before the learned JMFC. And only because of the interim order, this is for them also, if that is vacated, then learned JMFC will take into consideration whether that amount shall have to be
That is packeted. Earlier order.
not yet vacated, my lord. I have filed the IA and they have taken so
Consider
many.
all these things altogether, it's better. So what will be the date to produce the case diary? Yes, please.
Yes, very,
Yes,
1 week.
1 week. Today is 20,
uh,
20 is possible.
Yes.
So and so, so and so.
You know, some LCR also. Scan copy.
Scan copy, yes.
And CD up to.
Up to date.
My name may be reflected, Lordship, since Wakalatnama was filed. My name may be reflected, Lordship, since
Yes.
Wakalatnama was filed last year.
So and so, and all the addition will be paid also.
In that case, my lord, it may be fixed on 3rd October. Since I'll be having some difficulties. Given date.
Then production of CD by 30, by next day.
Or 20.
I was
So,
expecting
call for
your
the
lordship
case
will
diary.
dispose of the matter today.
Call for the case diary and the LCR. LCR pertaining to? Yes,
This
number?
JIMA application number, 58. 50 of 2022.
50 of 2022. 20.
3rd October.
After that will be fixed. After that, 310.
310. 310.
Lordship, can it be done on 16 if you have that date?
16, not that is 6. Puja vacation starts. Oh. Or 6th
6 of
October.
Okay, 6.
Highly obliged.
When?
Your lordship.
Yes, please.
Your lordship, in this case, your lordship, service report of respondent number 2, 3, and 4 is still awaited, your lordship.
Two, 3, and 4.
Yes, your lordship.
1, anybody's, I'm appearing for 1. That's fine. Your government?
Yes,
GP?
Your Lordship.
Yes. Additional? or
No,
just
government advocate, your lordship.
Government?
Government advocate.
Government. Respondent 1. Await service report regarding respondent 2, 3, and 4. And this is a matter after 2 weeks.
Much obliged, your lordship.
May I place your lordship? In this case, your honor, your lordship, the notice has been still levied. It's not been serviced till this date. To the sole respondent.
Sir, has not been served.
Yes, your lordship. Service is await.
For ready to petition,
Yes, your honor.
washing. The
No,
government is.
Not quashing, your lordship. It's for quashing the case, the cognizance that has been taken by learned CGM rowing for quashing the NI case. And there is an interim order as well where it has been stayed. So it may be extended, Your Lordship.
You've not taken any steps against respondent.
No, we have taken, but till now the service states that AD has not been received, not been returned to this honors court.
Do you want to take fresh step? Councillor Ansu, Clara Council for the petitions. Submitted that, Learned Council for the petitioner would like to take fresh steps against respondent. The petitioner shall take steps on service of notice to the respondent with the registered ID as well as the usual process, returnable within 4 days. Steps be taken within 7 days. List the matter.
There's an interim order as well, Your Lordship. On 5/8/2023.
8/5.
2023.
Interim order. Dated 17/3. Is extended till the next date of listing. Maybe I have already passed order. I have also given my signature also. Next step is.
So you only come in subjects.
Hmm?
You come in subjects here.
I'm nothing. Yes, please, next. 19.
Malad, I'm sorry, Malad, I was arguing my case in court number 1, Malad. My lord, at this stage, my lord, my simple case is, my lord, I am nowhere, my lord, the liable. Legally, my lord, the unenforceable, my lord,
Yeah,
the,
I said it's present.
my lord, state performer respondent otherwise, my lord. At this stage, my lord, notice may be issued and my lord, the impugn order may be, my lord, interfere with notice, my lord, returnable within 4 weeks, my lord. My lord, I am nowhere and my lord, involved. But there is no my lord, enforceable legally right, my lord. I have neither my lord, entered into any such contract agreement with the my lord, the respondent number 2, nor SEC has been issued in favor of my lord, the respondent number 2. But the Lorraine court below, my lord, without considering all yes, these aspects, my lord, the liabilities has been fixed upon me, my lord. So therefore, my lord, this is the impugn order is at annexure 1, page number, my lord. Yes, madam. Page number 1. Sorry, page number 21, annexure 1. So at this stage, my lord, my simple case is, my lord, I am nowhere, my lord, illegally, my lord, payable and my lord, having any debt and liabilities towards my lord, the respondent number 2.
Respondent 2.
My lord, respondent number 2.
So issue notice at
My
this
lord.
stage.
And my lord, it is conviction, my lord, and it is sentenced me to pay, my lord, such huge amount of rupees. I am a villager, my lord, nowhere I can pay. So at this stage, my lord, till such time, my lord, that maybe state.
Where is the judgment?
My lord, annexure 1, page number 21. It starts from, my lord, and page number 23 is the judgment and order dated passed on, my lord, 21st August 22, my lord. Sentence, no. And offer one judgment, my lord,
Page number
22, my lord.
22.
My lord, 21, it starts from 21 and page number 22, where the specific date has been given, date of which judgment is reserved under section such. My lord, 4.
Judgment is reserved.
No, my lord, judgment has been passed, my lord. This is the judgment, my lord.
Where is the operative part?
Operative portion is, my lord, page number
41.
41.
my lord, 41. Judgment pronounced in the open court by separate order. The acting under section 255 of 2 of CRPC and by judgment and order dated 30th September to 30th November 2017, the accused so and so. My lord, this name is also not correct, my lord. My name is not Mr. Tadar Niglar, my lord. This name is different again. And the summation, I am my lord Vibhut Ali and Rekar Tato, but my name is not Tadar Niglar, my lord. But wrongly this has been given. However, my lord, that can be corrected by the London Court below, my lord. Conviction is, my lord.
Where is the conviction that if I am?
Conviction is, my lord, is at page number 42, my lord.
42.
My lord. I have considered the submissions made on behalf of the both the parties and have also perused the record. Perusal of the file so state the conviction has contested the present complaint with any plausible defense in his favor, despite the admitting his liability towards the complainant, merely in order to deprive the complainant of their lawful dues for a considerable period of time. Be that as it may be, I am of the considered view sentencing the convicts for compensations of the check amount will advance the cause of justice. Convict series Rekar Tato, accused number 1, and Sri Vibhut Ali, accused number 2, are sentenced to pay fine of Rs 22 lakhs, just double the amount, my lord. 22 lakhs 80,000 for the offense punishable under section 138 NI Act. In default of the payments of the fine, the accused Rekar Tato, accused number 1, and Sri Vibhut Ali, accused number 2, shall undergo simple imprisonment for a period of 1 year. By exercising the power under section so and so, the out of the total amount of Rs 22 lakhs 80,000, a sum of Rs 22 lakhs 50,000 is ordered to be paid to the complainant as compensation, and Rs 30,000 is ordered to be remitted to the state. This is the manner of
Only fine amount.
Madam,
No
yes, fine.
sentence. Imprisonment is.
I'm not imprisoned.
Not yet.
Fine.
Fine, madam.
NIA, it becomes double.
Yes.
NIA,
NIA.
under upon 38, it becomes double when convicted.
There is a provision for double the amount, madam. And this is this, madam, notice may be issued and, madam, this impugn order may be, madam, kept away.
Why the revision?
Madam, the revision is, madam, I am nowhere, madam, liable to fail. There, madam, I could have preferred the appeal also, madam, admittedly, madam, admittedly, appeal is only possible when the person is liable to fail, madam.
Yes, Rakar Tato and Biput Ali,
Madam,
both of you.
both of them, madam, for the accused person.
Both the accused person.
My lord.
So first you have to prefer an appeal, then revision.
Well, the revision is is only possible when when the accused person has the liable to having that liabilities to pay and the debt, madam.
It
But-
is the order of chief judicial magistrate. So
Madam.
you have to prefer an appeal first.
Yes,
Well,
like,
appeal is only possible when I am legally enforceable, madam.
You have been convicted. Either no imprisonment is there, you have sentenced to pay a
Admittedly,
fine
madam.
of so and so.
Well, the convictions are based on the wrong presumptions, madam. Therefore, madam, the appeal is only possible when, madam, the persons having issued the, madam, if I am the drawer and he is liable, madam, the fee, then only in that case, madam, admittedly, that is possible, madam. But I am the third person, madam, nowhere connected with the, madam, the persons who has entered,
But
madam.
it's different issue. You are not currently, you have to. prove
Yes,
that.
madam. So therefore, madam,
I think if appeal is the main. You have to prefer an appeal first, then against the order of the sessions court, then.
that is only possible when I'm agreed by the, madam, if
You are
I'm.
the agreed person. but
Well,
you
I am
say-
agreed person, but just I've been made scapegoat, madam. That is the whole problem, madam. So therefore, madam, this is may they take your lordships to the agreement, madam. Agreement was entered between the persons who are, madam, not at all connected to me, madam.
It's a 138 matter,
Correct,
138
madam.
AIA.
Correct, madam. So
Check
therefore, madam,
was-
this is the only technical, madam, that, madam,
Check was issued by you.
check was issued by me in favor of some other person, madam. Not to this, madam, respondent number 2. That is the whole question, madam.
Respondent.
Respondent, I have never issued any check to this respondent number 2. Check was issued in favor of some other person, that some other persons from whom, madam, I have taken loan. And he has handed over the, madam, check to the third party, madam. That is the whole problem, madam. So therefore, madam, at this stage, madam, the only thing is that, madam, the person who is not at all liable to pay has been directed to pay, madam, and the sentencing, madam, me to undergo such imprisonment is not, madam, tenable, madam. It is absolutely, madam, absurd, madam. It is absolutely not tenable in the eyes of law, madam. Had there been, madam, this such transaction made between the, madam, the respondent number 2, who is the complainant, and the drawee of the check, then, madam, matter could have been in different position. But look, madam, but I haven't any idea who is.
This court has limited power in revision. This court has limited power. The better option is to file an appeal.
Madam. Subsequently, madam, if such is the position, madam, I'll prefer, madam, in the meantime, madam, since this is imprisonment, madam, again, I'll be, madam, in prejudice.
Actually, revision doesn't lie at this stage, I think.
Madam, unless-
You have to check, yes,
yes,
please.
374, appeal against conviction.
Yes,
After,
It is not exactly a conviction. It is just.
it's a conviction.
Like
So
convic-
first we prefer appeal.
it's a
madam.
conviction, but only sentence.
Sentence,
Fine.
madam,
Fine.
sentence.
The fine was
If sentence to undergo,
It's
madam.
conviction.
Madam.
Conviction.
Madam, conviction,
You're
but
asked to pay just fine.
fine,
Fine
madam.
up.
Fine of, madam.
Then they can go for appeal.
Madam, I feel otherwise also, madam, the civil, this revision, there is a provision for revision also, madam. Therefore, I have specifically quoted, madam, paragraph, page number, madam, first page, madam, page number 1, CRPC, madam, 479 and 401.
379-401 of the Code of Criminal Procedure against the judgment in order, my lord. There is a provision, my lord. Provision for revision, my lord. This provision is, my lord, enabling me to, my lord, file and prepare this criminal revision petition, my lord. Therefore, I prepare, my lord. For 397 and 401. my lord.
There,
Yes, my lord.
the line.
High Court,
4014.
my lord,
You see, 4014,
my lord.
where under this code an appeal lies and no appeal is brought, no proceeding by revision shall be entertained at the instance of the party who could have appealed. Who could have appealed?
My lord, in case of any proceeding, the record of which has been called for by,
614, that is applicable in this case.
my lord. When it comes to its knowledge, the High Court may in its direct exercise of the power conferred under the appeal. So and so, so and so. When judges compromised in revisions are equally divided in opinions, the case. my lord.
It's okay. See, I'll pass the order. I will pass the order. You can file an appeal, go for appeal. That is applicable. That provision is applicable.
My lord, admittedly, I've checked out from the record, my lord. If I prepare the, my lord, appeal, there is another local impediment on my part, my lord.
Okay,
Therefore,
it's
my
all
lord,
right.
my lord, therefore, my lord, may I again, my lord, take your lordships to. My lord, if appeal is prepared, there is a statutory provisions wherein, my lord, statutory deposit amount has to be done by me. My lord,
Ah, definitely, 20%.
so, my lord, the thing is that when I'm not at all liable to pay, my lord, first innings, the first innings, the liability, my lord. My lord, again, I'll now, my lord,
That
just,
will be refunded if you are not liable to pay. That will be refunded after.
my lord, the refund,
completion of
my
the
lord,
trial.
only for the whole, my lord, the refund is only possible after, my lord, there is a provision for making payment to the, my lord, the complainant, my lord.
You are convicted in this case. You are convicted, no? Conviction is there.
Conviction is, my lord, exactly not a
You are
conviction,
to pay the fine, though no imprisonment is
my
there.
lord. Imprisonment is not there. Sentencing
Then
only to, my
Only
lord,
sentenced to pay a fine.
pay a fine, my lord.
Then conviction is there. You're
My lord.
convicted.
My lord.
Second conviction appeal lies. Where no appeal is brought as per 4014. Then no revision is entertained, no revision lies.
My lord, revision is, my lord, as I have pointed out, if I am, my lord, the prepared appeal against the, my lord, conviction by this, my lord, this impugn order, my lord, as again, I have pointed out, my lord, the section 148, my lord, wherein,
You have to pay, you have to pay that.
my
This
lord, that is the whole
statutory
difference.
provision.
My lord, there is a provision for making payment to the complainant also, my lord. If after the, my lord, if appeal succeeds, my lord, again, that amount has to be returned back to the, my lord, the owner, my lord. But then, my lord, difficulty is, I am not at all, my lord, liable to pay single penny, my lord. Even deposit of the statutory amount is also, my lord,
The law is there, law is clear. If there is a provision, you cannot go beyond that.
my lord,
4014 is clear.
four 39, my lord, 497, 397, my lord.
Not 397, 401. you can't.
Just for a moment, may I read, my lord?
397.
397. The High Court or the Session Judge may call for and examine the record of any proceedings before any inferior criminal court is situated within its territory, within its or his local jurisdiction for the purpose of satisfying itself or himself to be the correctness, legality, and the propriety, propriety of any finding, sentence, or order recorded or the fast or is that the regularity of the any findings, sentence, regularity of any proceedings of any inferior court, and may, when calling for such record, direct that the executions of any sentence or order be suspended if the accused is is confined, that he be released on bail or is on his own bond pending in the examination. So the ample power has been granted to this honorable court by which the revision can be exercised. Had it not been the case that if at all not given the just power and the provisions, yes, I could have exhausted the another provision. But here the provision is still vested with this honorable court. Ample power has been granted, and by the virtue of this section. For 397 is the enabling provisions, where I can prepare the revision also. Appeal is not always the things which has to be exhausted by the even the petition.
Okay, I have to check on passing. but right
Madam.
now- Yes, please. Next.
In such case, if lordship is passing such at least such even granted, maybe granted liberty. And if issued notice by virtue of these provisions,
I want to see whether revision lies or not at this
Madam.
stage, then I will pass up.
and in the event of such passing, at least liberty may be granted, to file a phrase, one thing, other thing, if notice has been issued by your, after considering entire thing by your lordship, at least if you know that may be suspended till the returnable date. Deeply applicable.
Please, my lord. My lord, this matter will be posted on 3rd October. Meantime, my lord, NCR may be called. Question number 23, my lord.
Yes, yes.
NCR
Yesterday,
will-
no? Yesterday, you want to argue the matter?
Yes, yes. My lord, in this case, LCR is required. LCR was not called earlier, so. my lord,
LCR is
may-
required.
Yes, ma'am. LCR may be called.
LCR is not. LCR is not okay.
Not this. Not even called.
So I'm just going to- What for the LCR? For the 90? The order passed by the DC, no? No, DC.
Village authority come addition.
Oh, village, village. So where it is available? The record is available in Tower office?
My lord, actually they are saying that ADC has not passed this order.
ADC,
Yes.
ADC passed this order. That is why I'm asking. you. Case declaration order, no?
Yes.
In connection with case number, so and so. Which case number? From the office of deputy commissioner, no? Kurum Kame district,
Yes, madam, Kurkuma district.
from the office of deputy commissioner. One from the report from which office?
All Nyapin Circle Gaon Bura,
Yes,
all Nyapins. All Nyapin Circle Gaon Bura, Amalu Welfare Association. This declaration has been.
no, the order was, can understand, the order was all, that is general secretary. Where the record is kept. The final order was first by the ADC, no?
Milord, this
Declaration order was passed by the.
No, the
Kambura
ADC, somebody. Any people for the LCR.
Yes, ma'am. I'll share the report.
this final order actually is passed by the Blaze Authority.
First by the Gabura, no?
Gangbra, yes, yes. Page 29.
Yes, yes, I'm saying. So
59,
his status
let's
still
share.
record is required.
My lord.
His status is. From the concerned authority. For the record. the concerned authority.
Madam, can list on 3rd October.
Less than matter after 2 weeks.
No, madam, on 3rd October.
Yes,
On 3rd October, 3rd October.
3rd October.
3rd October.
Yes, ma'am.
3:10.
Yes.
Okay, 3.
Much obliged.
Your lordship, that's unlisted matter.
Yes. PP. Yeah, okay.
May I lordship?
Yes, please.
So instant bail application is being filed by one Ray Tagam, who is the chairman of one society, clan-based society called Ray Welfare Society. And the instant case is FIR has been registered on 20th August 2023 by one lady, daughter Sarah, for alleging that there was some burglary at her house. So may I read through the FIR? It's on page number 14.
15.
Yes, 15. So that Mrs. Daughters Sorabas, a resident of Nigam Colony, Naharlagan, would like to inform you that my house had been robbed last night by some miscreant at around 3 to 4 a.m. It would be very kind of you if you will look into the matter. Things robbed from my possession: one gold chain, rupees 2 lakh, one earring, and rupees 70,000, local ornament value of rupees 15 to 20 lakhs, cash rupees 1 lakhs, 2 mobile handset rupees 50,000 bearing IMEI number such and such. Accordingly, NLGPS case number 136/2023 has been registered and endorsed to SI V. Lingi for investigation. So subsequently, Naharlagan Police Station, my lordship, if you turn page number 17, there is a gist of FIR. Page number 17. Page number 17. If you go through this gist of FIR, it's read like this. On 20th August 2023, a written FIR was received from Srimati Dotek Sorabasa, wife of such and such, and Nigam Colony, Naharlagan, that on 20th August 2023, between 3 to 4 a.m. hours, some unknown miscreant entered her house by breaking the lock of her door and stole away property, including gold chain, mobile phone, and local jewelry worth more than 30 lakhs, hence the case. So, progress of the investigation. PO was visited, rough sketch map drawn, and complainant examined. There is a CCTV camera covering the PO, which shows that two persons have exited the PO with stolen property. On 24th August 2023, at around 9 hours, it was learned that one of the stolen phones in this case, namely one Samsung Galaxy A, this is number, IMEI number, phone became active, and it contained SIM number bearing this number, and the number was active in Laluk, Assam. Upon the analysis of CDR of the said number, it was learned that one number 70059873337 based in Itanagar is in contact with 78965166726, and accordingly efforts were on the trace out the said number. Through efforts, the said number was found to be one Ramijul Haq Hussain of Rokua, Naugao, Assam, and temporary resident of Ganga, Itanagar. Upon his examination, he revealed that the said number, this is which he is in contact with, belongs to one Abdul Subam, son of Job Ali, Kutupur, Laluk, Assam, and he is the father-in-law of her aunt. He further agreed to take the police team there. So on 25th, page number 18, 25th, Nahalan police station, the police team, upon being guided by Nazimul Haq and his team, uncle's name Jamidul Islam, Ramizul Islam, and arrived at the residence of Abdul Subam at Kutupur, Laluk, Assam. The stolen cell phone Samsung Galaxy A34 with IMEI number such and such was seized from the possession of Abdul Subam, and on his examination, he stated that he had bought the said cell phone from one Azmal Hussain. The team then left for the house of Azmal Hussain, son of Rukudnuddin of Kutupur, Laluk, Assam, whose house is few hundred meters away from the house of Abdul Subam. Azmal Hussain, on being examined, stated that he had bought the cell phone from one Rafiqul Islam. The team then left for the residence of Rafiqul Islam, son of Jalaluddin of Keotholi, POPS Laluk, North Lakhimpur, Assam, along with Azmal Hussain. Rafiqul Islam, on being examined, stated that he had bought 7 phones, including the seized cell phone stolen in connection with this said case from one Miraj Ali. Knowing fully well that the phones were stolen, out of 7 cell phones bought by Rafiqul Islam from Miraj Ali, 3 more such stolen cell phones were recovered from the possession of Rafiqul Islam, bringing seizure of stolen cell phone to 4. Further, he stated that the rest 3 phones he have sold to different people in Lakhimpur town. Rafiqul Islam, age 22, such and such, was arrested on connection with the above mentioned case on 25th at 18 hours after long examination, as he had received the stolen property and is part of the gang that procures stolen property from Arunachal Pradesh, stolen by the likes of Miraj Ali. After medical examination, he is being kept at PS lockup for further necessary action. Rafiqul Islam, on being shown the CCTV footage, established that the 2 people who were seen coming out of the PO along with stolen property after having committed theft were Miraj Ali and Soidul, who is a driver based at Itanagar. Source engaged stated that Miraj Ali has house at Halifat Colony. Accordingly, police team left for the said house and found that Miraj Ali's wife, namely one Hussainara Khatun, was there along with her son. On examination, she stated that Miraj Ali had just left the house and had gone to the house of his friend Tachi Godak at Aman at Sod village. She further stated that Miraj Ali had just arrived from Lakhimpur, Assam. The party led by undersigned then left for Sod village. Upon reaching there, Tachi Godak was found at his house. On examination, he stated that Miraj Ali has left few hours ago. Upon suspicion, his house search was conducted. Huge catch of local jewelry and house-breaking tools were found and seized. The said person, Tachi Godak, was examined, and on examination, he stated that he, along with Morizul Islam, Soidul Islam, and Miraj Ali, have committed the said theft in the wee hours of 1908-2023. 22 hours to 4 hours. They plan to commit theft at the house of daughter Sora Basar, which was selected by Miraj and Soidul previously. Soidul brought his Bolero car and he then picked up Miraj, Tachi Godak and Morizul Islam. They went to petrol pump at A sector NLG Naharlagan to fill fuel of 700 rupees and arrived at the helipad near PO, place of occurrence. Godak and Soidul stayed in car, while the other two went committed theft and come back with the stolen property. After that, the four of them left for Miraj's house. From there, Soidul and Morizul left, followed by Godak. The stolen property was kept at Miraj Ali's helipad house. Later, Tachi Godak came back to Miraj's house and two of them left for Papu Hill, where they sold of the local ornament to one lady for rupees 1,20,000, of which the money was divided amidst. So for the perusal of our lordship, the application for this bail application is for this lady who received this local mala. Given the above fact, Tachi Godak, age such and such, address of this area, Naharlagan, was arrested on 25th.
Forwarding of the present petitioner. What
Yeah.
is the
Yes,
forwarding
now,
of
now,
present
now, just this is gist of the FIR and reason why this alleged accused is being kept in custody. Now let's come to this main bail application. So bail application is being filed for one lady who has received, who has bought local mala relating to in this instant case, where she paid 1,20,000 for that local mala. And that also at her only resident. They come to there by stating that they are in need of emergency of money. But that lady, she's languishing at Julie jail. But interesting fact of the case is that for the perusal of this court, the lady was arrested on 26.
No, 31/8.
26/08/2023.
Where
It's
is the
on
forwarding? Where is the forwarding? Arrest memo.
arrest memo is page number 21. And accused challan is in page number 22. So based on the statement of those five burglar, and they had said that they had sold one local mala to this lady. So
Where is it? It is not there in the.
yes,
Perusal of case diary, that is not possible.
it's
Call for the
in
case
page
diary.
number 19, your lordship. It's in on page number 19, first, second, third para. Page number 19.
Page number 19 is.
Page number 19, that there is a first para, second para, and third para. From third para, the said person Tachi Godak, that from there, Tachi Godak was examined. And on examination, he stated that he, along with Morizul Islam, Soidul Islam, and Miraj Ali, they had committed the said theft. Those 4 persons, they had committed the said theft in the wee hours of 19/08/2023 at 22 hours to 4 hours. They plan to commit theft at the house of that daughter Sora Basar, which was selected by Miraj and Soidul previously, their accomplice. Soidul brought his Bolero car.
That is the forwarding of other accused. Who were
Yes,
arrested
yes.
also.
So
That is the forwarding of this lady that I am asking you.
forwarding of arrest memo.
Yes.
Arrest memo is in 21.
That is arrest memo, you can understand, forwarding.
Forwarding.
Yes, this type of forwarding.
Uh,
Voice forwarding.
If you see the order dated 27, this page number 23.
23.
Yes, page number 23.
The order.
This page number 23, first, second para and third para. Because on page, on this 27 August only, she was forwarded to Judicial Magistrate First Class UPI.
Yes, please, call for the case diary.
Yes. May Lordship, the presently what's going on, that subsequently on 27 August, she appeared before this learned Judicial Magistrate First Class, and again on 31st, there was one incident happened in between this 27 and 31st August.
Yes.
And if you see page number 26, there is a clear-cut order. Page number 26, my lordship. In page number 26, its accused person, namely Mofizul Islam and Srimati Ray Amak, are produced before me on expiry of this date. Peruse the forwarding this. No apparent injury seen on the body of Mofizul Islam, and he stated that he is physically fit and fine. Now, my lordship, here the next line is very vital for this bail application, is that accused person Srimati Ray Amak has stated that she was assaulted by one police personnel, namely SISS Ja, while in custody. She has stated that she was not assaulted by IO, seen injury marks on her right arm and left cheek. The medical report suggests that they are fit. Peruse the case, this. The next, if you record, reveal that this court with order dated 27 as the production date on Saturday, observed no injury on the accused person Srimati Ray Amak, and she was remanded to 4 days police custody, which implies that the injury alleged was caused during her police custody. It's very clearly, recorded by the Honorable Learned Judicial Magistrate First Class. The IO has prayed for remanding the accused to 5 days police custody for further investigation, recovery of stolen articles. Considering that visible injury marks are seen on the body of accused Srimati Ray Amak, it cannot be ruled out that she was assaulted while in custody. And as such, I do not consider it appropriate to remand her to police custody. Continues. However, the nature of the offense and the fact that the investigation is still going on, the prayer of remand of accused Mofizul Islam allowed to enable the IO to investigate further. Accordingly, the accused person Mofizul is remanded to 5 days.
That is not required. They will
Yes.
just to-
Now here, next para is accused person Ray Amak is sent to judicial custody. Jail authorities to take care of health and safety of the accused person.
Yes.
Yes. Now here, the alleged accused, the allegation of custodial violence against the accused person is serious in violation of guidelines of the Honorable Apex Court in the case of DK Basu guideline. Therefore, subsequently, Honorable Court has set up inquiry into the said allegation. So the Superintendent of Police Naharlagun
Why this petition has been filed? Just praying for bail or anything else?
praying for bail.
Praying for bail
yes.
to call for the case diary. It's
No,
serious
praying for bail is that till yesterday, this lady who is a mother of one girl child,
Yes.
this lady, till yesterday, she was there in judicial custody. But what happened due to this, police has to submit their
But
inquiry
now
report.
She is in jail, no? Now she is not in police custody.
No, yesterday they just brought her to Naharlagun in different case by linking, whereas she is not involved in those cases. Here what happened? They had asked for remand by this Naharlagun Papu Hill case, and the family member, they went to there, and Papu Hill Station IO stated that we doesn't have a remand place, so we are sending to Naharlagun PS. So she is now at Naharlagun PS again. So
Is
it's
it so? Yes, Mr. Taru.
it's
She is in Naharlagun police or is in jail?
right now she is in Naharlagun PS. Yesterday only.
I have only a copy of petition, but here it is
So report is
bail
required.
rejection order.
is enclosed here.
Yes,
and
bail
annex,
rejection is there.
uh,
That's for
page
previous
20
one.
Page 28. As per the learned PP before trial court, as a magistrate, according to her, according to PP, from CD it reveals that he is a habitual recipient of the stolen property.
She's.
She
the
is
lady
the accused, yes, accused petitioner hearing.
That's why.
That's why 413.
Now, from this 27 to 31st August, meanwhile, she was there in police custody. Then that assault happened. So there was complaint and that was taken cognizance by honorable court. So there is an inquiry. So just for bargaining purpose, police are what they are doing, they're abusing the law by linking in different cases and trying to establish a.
So report is required. Where is she now? at
CD is
present?
required also.
CD is required, and where is the present whereabouts?
Lordship, she is a single mother and she is languishing there for last 17 days. So my lord may consider, because most of those recovery ornaments has been recovered and she is helping out for investigation. And for any bail condition, she will be ready. And she is living here in Naharlagan only. She has her own residence. Everything is there.
She is in jail custody or is in police station?
As per the record enclosed here,
Now also
she is now at judicial custody.
She is now in judicial custody.
Yes.
As per record.
Yes, per material available
Yes.
with the petition.
She is-
Yes. Because bail application was filed yesterday. And yesterday night only that Papu Hill.
Here, page 29.
Yes.
Rejection order of the page 29. It is in first para. In first para, page 29.
Page 29.
Yes.
Yeah, order is of 8 August. The incident happened in between, order is of 8 September, bail rejection order. And
First
the
para.
incident happened in between 27 August and 31st August. Before that, now all those case diary will be biased. Because those police officers, they are trying to bargain this same thing before they submit their inquiry report.
She is confined in district jail, Julie.
Yes, according to this, till yesterday, on record.
Yesterday, 8/9, the order was passed on 8/9.
Yes, order was passed on 8/9, but yesterday was 11. And till yesterday, she was in judicial custody. Now, yesterday late night, this Naharlagan PS and Papu Hill PS, they had brought here. So,
Brought her in the police station.
yes,
Maybe in connection with another case.
that's why, that's my prayer, that's my prayer that they are trying to convince this lady by stating that we will settle down the problem, and if you doesn't withdraw your statement against the police officer, we are going to link you in different cases. And here also, she has honestly bought at her own residence. They come to
Then you have to file an affidavit in this regard.
your lordship.
You have to file an affidavit in this regard that she was tortured by so and so, the position is so and so. Whatever you have submitted before this court, you have to write an affidavit, file an affidavit before this court.
By this applicant, right?
Yes.
Because
Okay.
before means denying or considering this bail, this honorable court may observe the fact of this case. Why she has been again means forcefully taken by this Naharlagan PS, because already in this.
Submission, we do not know the facts.
Yes.
So we have to check on all these things.
Because
Cities required and others.
just at present, she is only single lady, means mother.
Okay, I can understand. I have seen that.
Yeah, and apart from that, in Julie jail also, she has suffered lot because traumatically she gone naked over there inside. So that has been reported by those medical officer also, but I don't know whether that has been forwarded to this trial court or not. So at this stage, honorable court.
Mr. So-and-so, granted additional, Mr. Taro is present. This is an application under section 439 CRPC. Bring for granting bail to the accused petitioner in connection with Nahar Lagoon PS case number 13623 under section 380, 411, 413, 34 IPC. Call for the case diary
Along with status report.
along with status report. It is submitted by learned counsel for the petitioner that though as per order of the learned trial court, the petitioner was sent to district jail, judicial custody. And as per order dated 8/9/23, she has been detained in district jail Julie. But according to learned counsel for the petitioner that she has been brought to the police station, Nahar Lagoon Police Station on tomorrow,
Yesterday, 11,
11/9
at late night.
at late night. And since then, she is confined in the police station. A report is called for from the concerned police station and the jail authority also.
And they are saying that they will relate to this Papu Hill 2-3 cases. So
Is the matter on? Yes, please, in which state?
This is a matter of Nahalagan, so
Nahar Lagoon PS. So
Yes. Here-
after 2-3 days.
Yes.
they come brought.
3 days, today is Wednesday,
Today is,
Tuesday. Today's Tuesday,
Today's 12th.
Tuesday.
yes.
Then Friday it is
Oh,
possible.
yes, Friday, by Friday.
Friday, what is the date? 15, 15/9.
Meanwhile, Your Honor, Your Lordship, actually, at present situation, she means as per the information, she is there in Nahalagan PS and still
Yes, sir.
mentally, yes, yes,
Let-
mentally,
Court, no?
yes, mentally she is not stable now. Because for last 17 days, she has been tortured without any reason.
It is also reported that the mentally she
She
is
needs family care now,
stable and she has been tortured for last
17.
days. A report is, jail doctor is directed to submit a report regarding his present health condition of the petitioner. Inform accordingly.
Obliged.